Looks like we lost our legal scholars for the afternoon, except for the three of us, of course. But I'm sure they enjoyed their experience. I hope they did. All right, we're back in session. Call the next case, please.
State of Tennessee versus Dominque Justice.
Good afternoon, Your Honors. May it please the Court. My name is Paul Estep, and I represent the appellate in this matter, Mr. Dominque Justice. I've requested 4 minutes for rebuttal, and the clerk has already set the clock, so I'll just get right into it. The appellate asked this court to reverse the trial court's denial of his Rule 32F pre-sentence motion to withdraw the guilty plea. Alternatively, the appellate asked this court to reverse or remand the trial court's sentencing. My argument will mainly focus on the Rule 32F motion to withdraw the guilty plea. The argument on sentencing will be submitted based on the briefs. I might touch on one issue from sentencing, but it'll mainly focus on the motion to withdraw the guilty plea. Your Honors, Rule 32F of the Rules of Criminal Procedure provides that before a sentence is imposed, a court may grant a motion to withdraw the guilty plea for any fair and just reason. As we all know, fair and just is not defined. The Supreme Court adopted a balancing test based off the federal system in State of Tennessee versus Terry Phelps in 2010. My conclusion to all of this is that the trial court abused its discretion by denying Mr. Justice's Rule 32F pre-sentence motion to withdraw the guilty plea because the court failed to consider the effectiveness of Mr. Justice's prior counsel and the defendant's nature and background. I think it would be good to kind of go through a little bit of the law, the case history, to understand how Rule 32 is supposed to operate. Rule 32F is broken up into Part 1 and Part 2. Part 1 is pre-sentence withdrawals. Part 2 is post-sentence withdrawals. Rule 32F2, the post-sentence withdrawal, provides that after a sentence is imposed but before judgment becomes final, the court may set aside the judgment of conviction and permit the defendant to withdraw the guilty plea to correct manifest injustice. Manifest injustice is defined, it occurs where there's a constitutional violation, such as an unknowing, involuntary, or guilty plea. There's a Brady violation, there's ineffective assistance of counsel, or there's a denial of due process. All those things are ways that the court may accept a withdrawal guilty plea under manifest injustice. Pre-sentence motions to withdraw a guilty plea are supposed to be easier. The standard's not supposed to be as high for pre-sentence motions to withdraw a guilty plea. In practice, that's not how it's being played out. Rule 32.1, F1 is the pre-sentence motions. The fair and just standard developed from the federal system. It came from a Supreme Court of the United States case, Kercheval, in 1927. Then 50 years after that, the United States Court of Appeals for the D.C. Circuit recognized in the 1970s, United States versus Barker, the situation of pre-sentence motions, and sort of a federal common law developed regarding pre-sentence motions to withdraw. They developed some rough guidelines in that United States versus Barker case. The court describes these rough guidelines. The United States Sixth Circuit Court of Appeals articulated 7 factors for the pre-sentence withdrawal motions, which the Phelps Court described and then adopted. And that was in 2010. This history of the Rule 32F is helpful to understand the purpose of the rule and how they're supposed to be applied. Post-sentence withdrawals are supposed to be more difficult than pre-sentence withdrawals. It requires a showing of some major constitutional violation. Ineffective assistance of counsel, it's listed in ineffective assistance of counsel, Brady violation, all of that. That's not hardly how it's being applied in practice, though. Most of the cases that I've read, unless there's a constitutional violation underpinning a Rule 32F1 pre-sentence guilty plea withdrawal motion, the court does not deny, the court denies relief, doesn't grant relief. There was one case, I guess it was the state of Tennessee versus Rubin, where the defendant's attorneys told him, I think this is the correct case, the defendant's attorneys told him that he would be eligible for a judicial diversion, entered the guilty plea, then he found out he wasn't eligible for the diversion, so he wanted to withdraw the guilty plea. It was denied, relief was denied at the trial court level, but at the appellate court level, this appellate court, criminal appellate court, granted relief and let him reverse the trial court's decision, let that defendant withdraw the guilty plea. But in all the cases, in the situation where the defendant has a prior criminal conviction, misdemeanor or felony, it doesn't matter what it is, of any prior criminal conviction, and the defendant does not get on the stand and declare innocence, there is almost never relief granted.
Okay, let me ask you this, though. In this particular case, the court went through the Phelps factors, right?
Correct, Your Honor.
And made findings on each one.
Correct, Your Honor.
And one of the things he pointed out in the experience with the criminal justice system is that the defendant had been involved since early age, maybe 11 or 12, had a number of misdemeanor convictions, had been filing his own motions, and filed bar complaints against his counsel, at which the court felt showed that he had some more than passing familiarity with the court system.
That is correct, Your Honor.
It wasn't just like he had one conviction.
I don't think that he had never filed his own motions. He was represented by counsel at all stages, even going back to General Sessions Court. He was represented by counsel. I think the reference to filing his own motion was his attorney at that time, the attorney that took him through the guilty plea, drafted some kind of motion without that attorney's name on it. The defendant, he took it to the defendant signed it, and then that attorney filed it along with a withdraw his counsel motion. So there was never a time when the defendant himself filed any motions, and in fact, that one motion that was purportedly filed by the defendant, it was Judge Sexton at the time, was the judge in Claiborne County. Judge Sexton outright rejected that, said that that Mr. Justice cannot file his own motions when he's represented by counsel. So it was at that point that his then attorney came back to him, filed another motion to withdraw his counsel, and in it there was just one sentence to withdraw the guilty plea.
All right, well, going back to what my question was, the court made finding on each of the Phelps factors.
Correct.
And specifically set out on the record, it's the court's findings. What are you saying the court did that showed an abuse of discretion?
Well, the misapplying the law. The rule.
What law was misapplied?
Rule 32F. There's a balancing test with all these factors, and the court should have looked at the attorney-client history with this. He
did, though, didn't he?
Well, he did, and he has done what a lot of Court of Criminal Appeals cases have come out to be, which is denying relief because basically the defendant did not proclaim his innocence, and the defendant had prior criminal history. All these cases, those two factors are really the main factors.
But if the court found that those factors existed and gave them weight, then are you saying that the court should never grant these? Or my understanding is if the court goes through this and lays it out on the record, if it's abuse of discretion standard, then the Court of Criminal Appeals is not supposed to go behind them and substitute our judgment for the trial courts.
Correct, Your Honor. The law, as it's written, is not being, the balancing is, it's supposed to be a balancing test, and that's not occurring. The law says that pre-sentence motions to withdraw may be granted for any fair and just reason. The rule should say pre-sentence motions to withdraw shall only be granted where there's a constitutional violation or the defendant has no prior criminal record, because in practice, that's how it's being applied. There was a case, State of Tennessee versus Emily Brooks, decided in 2021, where that defendant filed a motion to withdraw 7 days after her guilty plea. But just like the defendant here, she did not proclaim her innocence at the motion hearing, and she had prior criminal convictions. So these cases,
Did
there's
the court make findings on the other factors?
in that case,
Yeah.
I would say so. Yes, Your Honor.
All right, well, again, I guess, what is the court supposed to do? Are we supposed to go behind on abuse of discretion, standard of review, say that, well, the judge made these findings, but we just feel like that's not the way this is supposed to be? I mean, how exactly are you saying we should be reviewing this?
Under an abuse of discretion standard, Your Honor, the court should send a message to the trial courts that the balancing needs to be a balancing test. It doesn't. The trial courts are going through these cases, and they're seeing the delay between the.
This one was
very long, yeah.
I was going to say, this was months long.
7 months long. We're not disputing that. We understand that is a long time. That doesn't work in his favor. But the balancing is basically on the.
What are you saying works in his favor?
What I think works in the reason for the delay, the lack of the effective attorney-client relationship. So that would be factor 2. And then his nature and background. That would be how he's never held a significant job, how he's never held a job of management position or significant value, and then the way he was born and raised, some of the trauma that he experienced growing up. So that's two factors for him. The delay is certainly not in his favor. There's no doubt about that. And this time and time again with these Rule 32F1 motions, it comes down to whether the defendant gets on the stand and declares innocence and whether the defendant has a prior criminal record. A lot of these Rule 32F1 motions are being closed out to defendants with prior criminal history.
But isn't that a factor that the court can take into consideration?
It's something that
And your client, it's not like I said, it's not like he just had one incident, like he had a driving on revoked license, 10 years before.
Correct.
He's had a long history of arrests going back a number of years.
Correct.
And a number of convictions, misdemeanors, but convictions.
Correct.
So I'm saying, I guess, I'm looking to see if we're inclined to go down this road, how do you give points or take away points, which is what the judge apparently is trying to do here, and trying to assess all these factors one against the other. And he comes up with an answer. This is what I think is this. I don't think this should be granted. And then we're, on abuse of discretion, we come back in here, and as long as he's addressed each of these issues and come up with a decision, it's pretty hard for us to turn around and say, we just don't agree with you, we're going to do something else. In fact, I don't think we can. We should. Made me mad as a trial judge when that happened. When someone came in and said, you did everything you were supposed to consider, we just don't like your decision, so we're going to change it. I mean, that's what we try not to do.
Correct. I understand that, Your Honor. My argument is a lot, it's not just, I guess maybe it's not just this case, that a lot of the cases that come before the Court of Criminal Appeals with these Rule 32F2 motions, there's simply, it comes down to two factors, whether the defendant declared his innocence and whether he has a prior record. And unless the other type of case that gets relief is when there's an unconstitutional violation, which is supposed to be for the Rule 32F2 motions. In Rule 32F1 motions, when there's a constitutional violation, like ineffective assistance of counsel, those types of cases also see relief. And Your Honor, we would submit, in this case, there was ample evidence of that type of situation, that the trial court illogically analyzed, didn't really take it into account. I see I've got 33 seconds left. I would like to make one more point. It's a point based on the briefs. The state points out on page 20 that the defendant essentially admitted to making numerous calls to people other than his attorney. In footnote 4 on page 21, the state indicates that there was no call log entered into evidence, but defendant's response to questioning is evidence that calls were made. Nobody here was at the hearing, so you have to rely on the transcript. If the state is going to rely on that exchange between the defendant and General Brewer, then you need to look at the entire transcript, the entire testimony, the back and forth between General Brewer and the defendant. Mr. Justice basically agrees with most of what the general asked him. He didn't really have much pushback. I don't know if that was for nervousness. He didn't really hold his ground. He got confused about some very simple questions, but in this issue, whether he was able to contact his attorney, he said on direct examination that it was difficult for him to talk to his attorney. And then on cross, it seems like he was contradicting himself a little bit with the exchange about the phone calls, but if you read it closely, he basically just agrees with a lot of what the general asked him, and I think that shows that he was confused. So if there's no further questions, Your Honor, we respectfully ask this court to reverse the trial court. Thank you.
Thank you, Counselor. General Ward, you ready?
Afternoon, Your Honors.
Good afternoon.
May it please the court, Garrett Ward on behalf of the state. Your Honors, this court should affirm the trial court's decision to deny the motion to withdraw a guilty plea in this case because the trial court appropriately exercised its discretion in denying this motion. Really, Your Honors, this case comes down to the Phelps factors. Judge Campbell, as you noted, the court did put on the record its findings for all 6 of the Phelps factors. It found that 5 of the factors weighed against granting the motion to withdraw, and 1 was sort of neutral, cut a little bit both ways. The court describes it as neutral. So the court here is tasked with doing a balancing test. It makes findings on the record for 5 of those, says they weigh in favor of denying the motion. There's nothing that weighs in favor of granting the motion. That's an appropriate exercise of discretion. That's exactly what we want trial courts to do in these cases, is make findings on the factors listed under Phelps and weigh them and come out with decisions. Just sort of briefly run through what the trial court found here, because I do think that the trial court's findings on each one of these Phelps factors are well supported by the record. I think first, Your Honors, we have to start in this case with the unbelievably long amount of time there was between the guilty plea and the ultimate motion to withdraw. The defendant pleaded guilty in June. In January of the following year, so it's the beginning of June, I believe June 4th is his guilty plea, and then January 24th is the first indication the trial court gets that the defendant is having any second thoughts, and that is, in this record, 1 line in a motion to withdraw as counsel. Defendant's trial counsel at that time, Mr. Deaton, indicated that the defendant wanted to withdraw his plea. We then go from January to September before we have a filed motion to withdraw a guilty plea. So June to January, 8 months, January to September, another 8 months. So we're looking at in the sort of light most favorable to the defendant, 8 months before this plea's, there's an attempt to withdraw this plea. That's simply too long. In Phelps, I believe the court says that 7 weeks is a significant amount of time. If 7 weeks is significant, 8 months is highly significant. Turning to the next factor, and this is where I really think defendant focuses his argument. He seems to maybe suggest that the trial court just got this factor wrong, and this is, second Phelps factor is, of course, the reason for the delay. Defendant seems to be arguing that there was a lot of delay here because I didn't have a good relationship with my attorney. He points to, in the brief, a number of, I think, 4 other attorneys had represented him. But what I want to make clear from the court is that the attorney who represented him at the time of his guilty plea, which was in June, was appointed October of the previous year. So he had had 8 months of consistent, uninterrupted representation with this attorney before he even pleaded guilty. This attorney continued to represent him until January when he withdrew. So he had over a year of representation from the same counsel, and he doesn't really offer any credible reason for why he was unable to formulate a good attorney-client relationship, or as to why the relationship had devolved to such a degree that he couldn't communicate this request to his counsel until 8 months after his guilty plea. So there's nothing in the record explaining this delay. So the trial court properly found that weighed against him. And I really think, Your Honors, that those are the factors the trial court mostly focused on. But it did note that the defendant at no point had ever maintained his innocence or suggested he was innocent. He never disavowed a really incredibly full confession over a 3-hour period with law enforcement. He never backed off from that. The defendant has never suggested he's anything but guilty of these crimes, and that's, of course, a factor under Phelps.
Let me ask you a question about the calls that were talked about, and
Certainly, Your
also
Honor.
the court mentioned about his inability to contact or talk to his attorney. And the testimony was that I think he said he talked to other people, he didn't talk to his attorney, if I remember correctly.
That is what he testified to on direct and a little bit on cross, yes.
Okay, but that was his testimony.
Yes.
And the fact finder in this case, the judge, listening to the testimony, his conclusion was that he was able to contact other people, he was able to contact his attorney, and he didn't.
I'd say that's a very fair summary of what the judge concluded in this case.
That would have been, and again, going back to the findings of the trial court, the factual finding like that would be something that we would be bound by because
Your
he
Honor.
was the fact finder.
Yes, Your Honor. The court essentially made a credibility determination that this testimony about being unable to contact my attorney just didn't hold up in the face of the defendant admitting on cross that he talked to all these other people on the phone. I believe he specifically admits to making these calls and even describes where he'd have to go to make them. So again, there's no reason for the delay, and really that is a credibility determination is at the core of that, and that can't really be disturbed. As for the other factors found by the court, it didn't place a great deal of weight on either one of them from the ruling, it seems. I'll just note that there's nothing suggesting any coercion in the circumstances of the plea. The defendant received appropriate advice from his attorney about this plea. That's, of course, exactly what we want attorneys to do, is give their clients advice. And then the defendant did have some previous experience with the criminal justice system. All 5 of those factors weighed against granting this motion, and in a balancing test, when 5 factors come out one way and no factors come out the other, and the court rules on the side of the 5 factors, there's no reasonable argument that that is an abuse of discretion. Unless this court has further questions, I'd ask that you affirm.
All right, thank you. Rebuttal? I think you have a few minutes left.
Yes, Your Honor. Like I said earlier, the court found 5 of the factors against the defendant, and it's inconsistent with some of the prior case law where there's a constitutional violation underpinning the withdrawal motion. If there's no other questions, we would ask the court to reverse the Rule 32F denial and then the reverse or remand the sentencing.
Mr. Eastep, thank you. Were you appointed on this case?
Yes, Your Honor.
I just wanted to say you've done an excellent job, and we appreciate your accepting an appointment like this, and hopefully others in the future, and we'll see you again up here. I'm sure the trial court appreciates your accepting appointments also.
Okay.
I know
Thank
a
you.
lot of times there's a conflict with a public defender, and we need good defense attorneys, so thank you. All right, one more to go, right? All right.
State of Tennessee versus Horace